Yes, P103B.
I'm sorry to interrupt my colleague, but I don't know if you can deal with the document the witness and say she doesn't know.
My Lord, I will have to be guided on how I should conduct cross-examination. Because I don't know, my Lord, of any limits.
Mr. Mwaganya, proceed with this.
Yeah, but my Lord, can the defense be guided? Give us some liberty to cross-examine.
Let Mr. Mwaganya proceed.
Most of
You
them.
will have your time to re-examine.
I'm aware, my Lord. What I want to say is that we need to be moving together. If he is referring to the document, he should tell us which document it is.
I said 103B. Yes.
Right.
Madam, in this document, which you say you don't know where it came from,
Mr. Mwaganya, she did not say she cannot. She said she cannot confirm.
Yes.
Madam Katanga, do you know where that document came from? So that document which you say you don't know where it came from. By the time it was authored, the author indicated that you were a known case of hypertension. Did that author indicate the truth of your condition, or he lied? Now I'm not asking about the document, I'm asking about the information. Please pay attention. The author indicated that you were a known case of hypertension on admission. Did that author represent the truth of your status at the time, or they lied?
I don't understand the question.
My Lord, may the question be made clear. I have made it as clear to the best of my
But what
knowledge.
can help? Mrs. Katanga, what's the stating that on that form, the person who filled that form stated that you had a history of hypertension. Is that true? That person who have a history of hypertension, is it true?
As I told this court before.
Is it true or not? My Lord, she will.
Can she be allowed to answer?
My Lord, one of these days.
Thank you.
As I told this court before, I had pressure.
My friend, is it true or we just want to know information is correct or incorrect? Please say that.
Where is that information?
Where you say the year of the EU, let me help you again. Okay, supposing that information was there, you can make it simple.
That's why I want to give an answer.
First answer, then you explain.
Let him not tell her how to answer. Let her answer. He has
He's
asked.
the one answering.
I am the one asking.
Mrs. Katanga, is it true or is it true that you are the case of hypertension for
At the time of
Answer yes and no. Because
the answer is yes and no. That is enough.
yes, I told
No,
you.
let her
the
explain.
answer is yes and no.
My Lord, I will be in charge of my process of cross-examination.
Yes, Mr.
Then let the defense not
But
determine.
also, the record has to reflect something that can help. Because if someone says yes and no, let her explain the yes and no.
My Lord, will the defense do that?
My Lord, answer cannot guard.
My Lord, let's remember the cross-examination of Chisitu.
Yes.
One person at a time. counsel to the defense, one person at a time. Mr. Kabeka, I have heard you. Mrs. Katanga, you say yes and no. So the yes is?
As I told you something before, I had that was on the edge, on that, but I was not under pressure. Never had this pressure that I had.
So you had pressure, but it was
Not this.
And then no? So is the no that it was there but not as it is now?
Yes.
So precisely, it cannot be correct that you developed pressure because of the alleged assault that you told court.
To this magnitude, yes. It accelerated it too much.
So I'm first going to take you to some of the most obvious things that we think we require from you. Just to confirm that you own joint businesses with your late husband.
Yes.
Those joint businesses included companies.
Ongoing duty. The prosecution is obliged to disclose to the defense any information that they may come across, particularly if it is going to be relevant in cross-examination. At the bar, the defense, the state has disclosed the documents to the defense at the bar, which is okay, considering in this case that the documents we are talking about are documents that the accused person stated are documents relating to her companies. Memorandum and articles of association, copies of resolutions, and company form. Section, this is the case. This is the ongoing disclosure is acceptable in this case, because it was impossible for the prosecution to anticipate beforehand what would be relevant for cross-examination even before the accused person. What is important is that at the bar, the documents have been exchanged, and any prejudice that may have been suffered by the accused person is mitigated by the fact that these are documents that are documents of the accused person, and the accused person has stated that they have company documents. Section 4 of the Evidence Act, which the defense has cited, states that evidence will be given of every fact in issue and of such facts that are relevant, of such other facts that are hereinafter declared to be relevant. Whether the cross-examination and the line the prosecution is taking is relevant or not will be determined at the end of this exercise. The prosecution has submitted that their line of questioning leads to a place where the relevance of their line of questioning will be will become relevant to this court. There is, in my view, no prejudice suffered by the accused person by the documents being traversed by the prosecution. If the matter is that of authenticity of the documents, that can be addressed in re-examination and also in submissions. It is my view that Section 144 does not apply in this case, as the writings the prosecution is relying on to cross-examine anyone on not relate to previous statements made by her or him or made by her in the strictest sense. I don't know whether that word applies in the strict sense of the word, but rather they are copies of constituent documents of the company and copies of documents relating to company decisions. Section 10b of the Evidence Act states that facts, when otherwise relevant, are relevant if by themselves or in connection with other facts make the existence or non-existence of any fact in issue or relevant fact highly probable or improbable. As I stated before, this can only be determined at the end of the existence. Section 145 talks about questions lawful says that when a witness is cross-examined, he or she may, in addition to the questions here before referred to, be asked any question which tend to test his or her veracity, discover who he or she is and what his or her position in life is, to shake his or her credit by injuring his or her character, although the answer to those questions may tend directly or indirectly to incriminate him or her, or might expose or tend directly or indirectly to expose him or her to a penalty in forfeiture. The other questions that may not be asked in cross-examination are questions that are intended to demean or belittle. The conclusion is that the prosecution is required to traverse the documents relating to the
Madam Molly, please note that we intended this to be a very short exercise, and we are only dealing with things that should ordinarily be in your knowledge. So please, where you have to confirm, let's do it quickly, and we wind up this process. So for this company, Ford March, is in your knowledge that it operated the bank account, the USD bank account with the Stanbic Nakasero branch. Is that something in your knowledge?
Yes.
It also operated a Euro account with the Stanbic Garden City branch.
Yes.
That company also had a UGX account with the Stanbic Nakasero branch.
Yes.
So I want to refresh your mind further by looking at the documents. I'm beginning with the dollar account, USD. So I'm giving you a copy of the KYC banker statement, KYC, your own company documents that you use to open a bank account, and also the banker statement.
My Lord, I'm sorry, but at the risk of being pedantic, and I do apologize, I am again objecting to this line of examination. My Lord, it violates section 2 and 3 of the Evidence Bankers Book Act. My learned friend is introducing the evidence in this court, evidence of a banker's book. Section 3 of the Evidence Bankers Book Act provides that the proof may be given by a partner or officer of the bank, may be given orally or by an affidavit sworn before a commissioner. Section 3, subsection 2. My Lord, section 2, maybe if I can give the whole scheme of the act. Under section 2 of the act, copies of the banker's book can be received in evidence. Under section 3, a copy of an entry in a banker's book shall not be received in evidence unless it is first proved that the book was at the time of making the entry one of the ordinary books of the bank. So before any evidence can be given about a banker's book, it must first be proved. And the proof must be given by an officer of the bank, orally or by affidavit. My Lord, this witness is not an officer of the bank and is not competent to speak to the evidence of bankers' books.
What is it? When does it move from being the property of the bank to the property of the
book is always the bank. The book
is a statement, a bank statement, a banker's book?
Yes. Otherwise, there's no other way they could have gotten it.
My Lord, in addition to the submission of my learned friend, I would like to add this. But my learned friends are trying to produce in evidence a document from the bank where a police officer went to a magistrate's court and sought an order. I wrote when this matter, when the accused was committed, this matter was no longer in the hands of the lower court, magistrate's court. It became in the hands of this court. Now, my Lord, you see in this document that there is an application to a magistrate's court by a police officer on the 8th of April. And his affidavit, this month, yes. In the affidavit which is attached to the application, he says, by rank AIP Phenom John Vincent, attached to CPS Kampala here. And he says, I'm an investigating officer in the case of murder in Road Police Station, CRB 10/7/2027. My Lord, before you this court, nowhere, there is no evidence whatsoever that this officer was one of the investigating officers in this case. And he says, it is therefore a requirement to inspect bank account number that. And I therefore pray that a court order be made authorizing me to inspect this account and take copies of the documents in connection with lord, this is a false affidavit. And not only that, when he goes in a magistrate's court to seek for an order, when the case is being tried in the High Court, that, my lord, borders to forgery. Good. Therefore, my lord, there is no way these documents allowed based on that.
Mr. Morgan, the case is still submitted.
With the permission of the court, my lord, I just want to add shortly that the matter of companies and bank accounts and all this matter was never part of the prosecution. Never. This is an attempt to reopen the prosecution case. It's true. It's been said many times. You all know that in a cross-examination, you have wide leeway to ask questions. And those questions must be relevant to the issue in the trial of that particular case. If the prosecution had wished to make investigations on various companies, or who is the president of Gabon, or whatever, they should have included it in their case. It's not that we are complaining about relevance relating to the case. We are complaining about relevance to matters which have nothing to do with the case which the prosecution brought. Now, a few days ago, the prosecution has now new investigating officers, investigating companies. 8th of April, long after they had closed their case. If they want to reopen the case, their provisions in the law allow them to do that. You can deal with that. But my lord, we cannot open the case to the whole world. Talk about the deserts and oceans and make those relevant to the case. It's another trial. It's not a company matter. If they had wished to link the company's matters to the matter trial, they should have made it part of the prosecution. And no wonder they haven't been right for reopening the prosecution case, because that is it. We are hearing of court proceedings in other courts that have to be smuggled here, which include definite falsehoods. This man, whose name I can't even remember now, was not an investigating officer in this case. He told lies before another court, and those lies are being smuggled here. This trial, if we proceed with this line, why were we not involved with the application? Why was the court not involved in this investigation? Post-prosecution case,
My Lord, Section 144 includes a matter of relevancy. It must be relevant. You can't wait until someday you decide whether it was relevant or not. You never close this case. My Lord, let's see the case the prosecution has presented to your Lordship. No new documents, nothing, unless the court has authorized it. It hasn't authorized it.
My Lord, just one last point. My Lord will recall that during the cross-examination of Akongo Bibiana, the defense requested for a production of all documents that were in Henry Katanga's office. And this court told us to limit ourselves to the matters that are relevant for our trial. My Lord, the same rule must apply to the state, because nobody knew where we were going with what we wanted, but we were stopped from going there. My Lord, the danger is giving this prosecution a wide carte blanche to start fishing. They may want to fish, but the court should not allow it.
The evidence Bankers Books Act, Article 9, Section 1 defines bankers' books to include ledgers, day books, cash books, account books, and all other books used in the ordinary course of the bank, the business of the bank. Section 2 provides, or the same act provides, that a copy of any entry in a banker's books shall in all legal proceedings be received as prima facie evidence of that entry and of all the matters, transactions, and accounts recorded in it. Section 3.1 provides that a copy of any entry in the banker's book shall not be received in evidence under this act unless it is first proved that the book was at the time of making of the entry one of the ordinary books of the bank, and that the entry was made in the usual and ordinary course of business, and that the book is in the custody or control of the bank. Subsection 2 says that such proof may be given by a partner or office of the bank and may be given orally or by an affidavit sworn by any commissioner or person authorized to take affidavits. In the case of Kawesi Sulaimani and 26 others versus Bank of Uganda and another, miscellaneous application number 0258 of 2022, court noted that the evidence Bankers Book Act covers ordinary banking records kept by a person carrying on banking business. Therefore, ordinary bank statements and similar entries will fall within that act. The Supreme Court in the case of Nakate versus DFCU Bank Limited, Civil Appeal number 1 of 2009. In this case, in the Supreme Court case of Nakate versus DFCU Bank Limited, Civil Appeal number 1 of 2009, a bank statement was admitted as defense exhibit 1 during scheduling conference by consent, and on appeal, the admissibility of that bank statement without complying with Section 3 of the Evidence Bankers Books Act was challenged. The Supreme Court held that once the document was admitted under the Act, in this case at a scheduling conference, Section 2 makes the statement prima facie evidence of the matters recorded in the bankers' books. It is my view that on admissibility of a bank statement, it must comply with Section 3 of the Evidence Bankers Books Act. However, at this stage, we have not reached the stage of admitting the said documents illegally. Questions are being put to the witness who admitted that she operates the businesses. She admitted that the documents put to her. There's the memorandum and articles of association, the resolution, and the company form related to that business. In respect to the two businesses, the accused person also admitted to operating various bank accounts. The questions being put to her from those documents are legitimate questions. Regarding the court where the court order was obtained, Section 6 of the Act states that on application by any party to a legal proceeding, a court may order that party be at liberty to inspect and take copies of any entries of a banker's book for any of the purposes of that proceeding. Section 6(2) of the Act says an order may be made with or without summoning the bank or any other party. There is no requirement to serve, involve the defense. In my view, there was also no requirement for the same court order to be obtained only from the High Court. The Act says a court may order. The DPP, who is a party to the proceedings in this matter, through its agent, the police, went ahead and obtained the court order. Regarding whether Mr. Twino lied in the affidavit about his being an IO and therefore that evidence be obtained as a result of that affidavit could not stand, fortunately we have case law to guide us on situations such as this. In the case of Colonel Retired Kiza Besigye versus Museveni Yori Kaguta and another presidential election petition number 1 of 2001, the Supreme Court cited the case of Yona Kanyomozi versus Motomat Uganda Limited. Supreme Court civil application number 6 of 1999, where Justice Mulenga, Justice of Supreme Court, held that in that case, some parts of the council's affidavit were false, and that those parts were relevant to the application and could be ignored. The Supreme Court noted that there is a general trend of taking a liberal approach towards dealing with defective affidavits. That this is in line with the constitutional directive enacted in Article 126 of the Constitution, that the court should administer substantive justice without undue regard to technicality. They went on to say that rules of procedure should be used as handmaidens of justice but not to defeat it. The Supreme Court went on to sever parts of the affidavits which were falsehood and relied on the parts which were truthful in support of the application. In this case, in my view, it matters not very much whether or not Twino Mugisha was an IO as stated in the affidavit while extracting the order. What is important is that Twino Mugisha was an agent of the DPP, obtained a court order to extract the banker books in this case, in accordance with Section 6(1) of the Evidence Bankers Books Act. Therefore, the prosecution may proceed to cross-examine the accused person on the documents relating to the business she has stated that she has operated, and also to cross-examine her on the bank accounts she admitted operating in various banks in relation to the various businesses.
So, Madam Katanga, we are on the USD account for March. That bundle has your particulars, the documents you use to open the bank account and the account details. You just confirmed to court that those are the details of the USD account at Stanbic.
We don't have what you're talking
My lord, I had passed it to them before the objections. Just confirm that those are the details of the USD account for which you operate for merge. You are free to go through all your documents. The documents have, you find your particulars that you used to open the account, including those of your husband, and the bank statement.
One statement I can't confirm because I don't know that it's a bank statement or not.
What can you confirm?
The company is act, it's merged redundantly. Both of us are shareholders.
You, both of you, you mean you and who?
And him with Katanga.
Okay.
That's what they can confirm.
Shareholders in what percentages, ma'am?
50-50.
Okay. What else? That is all. You are not in position to confirm the notice of beneficial owners, particulars? I also see it there. Go one by one and tell court what you can or cannot confirm. That one, don't repeat what you've said.
I don't know what she refers to as the Companies Act among the documents we have. Maybe our colleague should show you which is. There is no heading which has Companies Act, but she seems to be reading. Maybe our colleague should show her the document or this resolution. So maybe you should show her a particular document, she confirms, you move to the next one, instead of saying go through.
You will ask her in a re-exam to clarify what she meant. No? My Lord, let us have some time to cross-examine this witness. I'm finding it very difficult to cross-examine a witness on guidance from the defense. And my Lord, I say this with all due respect. Otherwise, we must proceed somehow.
Yes.
In fact, you can find that the answer she has given me is sufficient for me.
Then move on.
To save time, maybe go one by one.
Yes.
All of you start with us.
Yes.
Because we must start to
Can you go
through? Confirm and what you cannot confirm.
Can you go to the first document?
That's much better, my Lord. First.
The chief budget streets copy.
Leave that one, go to the next document.
Affidavit.
Leave that one. What is the next document?
Warrant card Uganda police.
Go to the next one.
The Companies Act.
Go to the next one. You have already talked about that one.
You said particulars of the persons who are directors.
Are you in position to confirm that?
Yes.
What do you confirm? Who are the directors? In what percentages? Okay, particulars of directors. Go to the next. What is the next document?
I see business, business, company, nothing from this return.
We don't see those documents. So my lord,
Can I have the document?
the documents we have are different, my lord. We don't have those ones.
Mr. Morgan, is this what you disclose that they
Yes. Yes, my lord.
I was had the court order, the affidavit, and the bank statements. So everything else she's reading.
Can you move to that
For example, this bank statement.
Yes.
Yes. This one.
Next one is Form 1. You are
Process of beneficial owners.
Beneficial owners.
Beneficial owners.
Okay. Now go to only the 3 I have marked.
Which has
what's the first one you do?
It's a board resolution.
Madam, what is the first one?
Board resolution.
Board resolution for?
For March, opening bank accounts.
You are in position to confirm that?
don't have.
Go to the next one.
My lord.
We don't have that.
My lord, I'm going to ask that we actually adjourn and we do this cross-examination.
No,
We don't have.
you see, if you claim you have provided and we don't have,
I gave the documents to Mr. Kabeka.
they are here, you can cross-check.
We can't be hiding a board resolution. We don't have it. We don't have it, Mr. Morgan. We don't have a court that doesn't belong to you. Give us the documents. Well,
No, we don't have
There, my lord.
my lord,
don't have them.
where do we see board resolution?
It's now, it's not there.
Let him give us his.
Mr. Kabeka, where is the bundle that I gave you?
The bundle is there.
It is this
Let
one.
me look at it.
This is there. The bundle.
We don't have it.
Enforcement of the
Can
Can we have that document? Anyway,
Is it there?
So correlate.
in possession of it. Let's have that.
My apologies, but Uganda come from so we went locally.
Can they look at the three? If they don't have, they can electronically have the copies.
No, we have to give them.
Give them those.
It's up to you. If we must proceed, we should.
Board resolution.
Just applying them now.
Yeah, board resolution, it's okay.
Dated.
So, it's 2029. This must be 5 second. We don't have it. So then the second one. So this time we'll look at the ones with tags.
So you have that one?
I do have. This is a bank statement. I think this is original. 10th.
So you have the third document, you have the second one, it's just the first one.
My lord, if it is only one, but it seems to have many annexures, but if it is only the resolution one page, you can just take a picture of it and continue. So, Mr. Moore, is it only one page? Resolution?
Resolution, my lord.
Okay. Yeah. You scan and remove. Let's make life easy.
It's opening the bank account.
I don't.
What is it on?
I only know the one of a check. I thought you see in cross-examination.
Mr. Morgan, you are the biggest objector to cross-examinations. You should not even complain. There is nobody who interrupted cross-examination more than you in the whole world.
Now you can see that I have not said anything, but Mr. Karanga is objecting.
I should be given a leeway. My lord, you couldn't even ask Bibiana about Beatrice's statement. You couldn't actually ask any question without Mr. Morgan's objection. You know? Actually, you should be shocked at the way we have really given him space.
Well, yeah, they have already made my mind tired, my lord. I'm just human. And I'm being sincere.
The mind is just weak. But
it is their weakness, my lord. We can always come back. And just for the defense to be sure, my lord, no amount of cross-examination will make us to divert from the instructions we have. No amount of objection. So if we can only object to what is relevant, my lord, we save a lot of court's time.
What instructions are these?
Ma'am, can you confirm? Or, you say you confirm the resolution. Go to the next document.
The next document.
The next. Your national ID.
Henry
Yeah? Please use the microphone. I need to hear. So we are on Henry's, eh?
Yes.
Okay. You go to the next ID. Those I marked them correctly. Do you also see yours there?
Yes.
Okay. Those two IDs are the ones you used when you are opening the bank account.
My Lord, I think you have a question.
I don't remember whether those two national IDs were used.
I don't remember.
But did both of you use national IDs when you are opening this particular bank account?
I don't remember.
Do you remember that both of you opened this particular bank account?
I don't remember.
He doesn't remember opening the account.
Doesn't remember
Whether both of them have ever opened this particular bank account?
I don't remember.
It's okay, ma'am. What is the next?
It's the bank statement.
Bank statement for?
I see much, but I'm not sure. I cannot confirm.
What is the account number that you see on that bank statement?
903-001-486-46.
I'm going to ask you to slow down. Account number for March, account number
903-001-486-4686.
4686. Do you still want to tell court that you don't remember whether that is your account number of March?
I don't remember. I can't have this in my head.
Okay. What can aid you to be sure whether that is or is not your account number for that particular company account?
With this technology, I just can't be sure.
Yeah, how can you be sure? This court wants to know, how can you be assisted to be sure that this is the said correct company account? You are the director and operator of that account. This court is not rushing you. How do you want to be sure?
What you have put before me, I cannot be sure.
Very well taken. So how, Madam Molly, do you want to be sure? How can this court be of assistance for you to be sure? You don't know. So what can aid your recollection of the bank account details that you operate, Stanbic Nakasero branch for March Uganda Limited?
If you give suggestions, I don't know.
You were operating this account before your arrest?
I was operating that accounts.
No, I'm on this particular one. I will come to others.
Yes.
She said March, I was operating March accounts.
Bank accounts.
Not this account.
This is real or not. I don't know whether it's authentic or not.
Do you have a record of the USD March account?
I don't have those accounts in my head.
No, I'm not asking this in your head. So, other than your head, where can you get this record?
I didn't get the
She doesn't know. You were also operating this account online. Do you have any record of this particular account that you operated?
We do here, no.
Where is it? Can you provide it?
I don't know where it is.
I'll say that one. Sure, to say that one, but you have to say that one.
I want you to confirm that both you and your husband were co-signatories to this account.
You are not. I was whichever. This one I cannot confirm. But merge accounts.
Don't go to others, ma'am. Let's be on this one. Let's be on this one.
This one she's not.
So
This one she's
I cannot confirm if my husband and I
Can I have the paper?
signatories.
I want you to look at the account opening resolution that you confirm authoring.
Which one is that? Is that the one you took a picture of? Is that the one you took a picture of?
That's the only board resolution.
My lord, that is a resolution for a different account from this one. That what we have a picture of is for a euro account.
This one is a dollar one.
Can I, is that for euro? Don't worry, I will always have the one for USD.
Which also have a given us.
For euro or USD? The one for USD. As they interpret my word.
Kampuni emuzambiro oba ya March ekaba eina akaunti ya ensimbi za heru eza dola mu banka emu eya Stanbic mu itali lyayo eya Nakasero yaba nendi ensimbi nazo za heru ezikotebwa euros nayo mu itali erindi erya banka eno kandi nezindi nendi musente za Uganda nayo eri Stanbic mu banka ya Stanbic mu itali lyayo erya Nakasero baitu ebihandiko ebimu ebikorwa mu banka ebikozesebwa banka ebimu tabyetegereze kandi takusobola kuteekaho mukono nti mazimako nibyebyo kandi tasoboire okwetegereza kandi n'okwikiriza nti ebyo bihandiko nibyo byamazima. Bombi babiri n'omunywero we bakaba bona bali bakulu omu kitongole kino lundi omu kampuni eno nkugamba uwe akwetebwa Molly Katanga na omunywero Molly Katanga. Aikirize nti bese zikolekebwaho ziri zabo babiri ezakozesebwe okukingura obuteekamu bw'okwahura mu ssente mu banka zino baitu takusobola kumanya kurungi nti bw'omazima nizeezo bakozesize kandi takwikiriza kurungi era nitakumanya kurungi nti ebihandiiko bino byamazima kandi takubijuka nti nibyo byenyini bakozeseize okukingura hali baali nibahura sente ezo batwekako enamba ezihandikirwe eziri 9 noti 3 noti emu 486 kandi takumanya mulingo ki olutalo lw'amateeka lusobola kumukonyeramu okugumya nti ebyo nibyo ebihandiiko kandi takwijuka nti bakaba balina hali bakwahura obakaba nguni bahura batyo obakaba batakamukwasire baitu amazima gali titakujuka ekintu kyona kandi takusobola kwijuka kandi takumanya nti akusobola kuba alina ebihandiiko bino ekigambiraho nti akaba alina enkora ya harutimbe lwa intaneti nakyo kyakikirize atugambireko nakyo tigali mazima kandi takumanyira kimu ekintu kyona ekikubye okukwataho nokukwakubaire okwikiriza lundi okugumya nti boona bakani bateekaho emikono yaabo omubugufu habihandiiko bino.
Madam Mola will come back to the USD. Now I am on the Euro account.
We don't have the Euro account. Share.
You confirm that your company, Madam, my Lord,
We don't have it.
My Lord, what question have I so far asked on the Euro account?
You have directed that to the Euro account.
I've not handed her anything yet.
You are not going to the Euro.
Yes, my Lord.
You're going to ask about the Euro.
I will, my Lord.
It's close to them. Let them take a picture. So when we get there, we don't have any single objection.
Why does he want to ambush on it? I don't know why.
My Lord.
They have just said that they have one for Europe. So what is
What does the defense want me to do?
To be organized and disclosed.
Okay. My Lord, this entire thing about disclosures is being blown out of proportion, my Lord. This is not my witness that I'm leading evidence in chief. Once I put documents to her, at an appropriate time, I will pass over those documents to the defense. But I cannot be bogged down.
You're not traversing.
Yeah, my Lord, once I do, I will. I will, but
You see, this time we have spent.
Yeah.
We would have taken a picture and would have...
My Lord, it's not a question of picture. Can the defense be patient with us? And we know. They should not assume that they govern how we operate, my Lord. We know we have a strategy. But before I put any questions, they are demanding for documents.
Because you said that now you're leading.
Yes, my Lord, they should be patient, my Lord. We are being bogged down. My Lord, I say this with a lot of respect. We are being bogged down in this cross-examination. We choose which documents to put to the witness and when.
So you've given the documents.
I have not given anything, my Lord.
You say, I recorded that the witness is directed to the statement of the Euro account.
No, my Lord, I said I am now going to the Euro account.
But you're directed.
My Lord, I have not yet gone there. I have not yet gone there. And when I do, I will pass over the documents. But it is unbecoming, before I do what I have to do, for the defense to bog me down. Then I fail how to work, my Lord. This is cross-examination.
My Lord, I'm sorry to interrupt my colleague, but I think disclosure is a constitutional right.
Disclosure at what stage, my Lord? Disclosure at what defense? In cross-examination? My Lord, where is the law? Where is the law that before I cross-examine on a document, I must first disclose it?
Yes, my Lord, give him the law.
Let him raise his objection.
Yes, my Lord, Article 28 of the Constitution on the right to fair hearing is that an accused person shall be given adequate information and facilities to prepare for her defense. The idea has been decided by the Constitutional Court, and that means there must be pre-trial disclosure.
Yes.
This person is prosecuting that person. He cannot say that in his prosecution, disclosure is overstated. The rights in the Constitution, however angry our Constitution may make the prosecution, the rights in our Constitution must be respected. Pre-trial disclosure to an accused person is not a favor granted by a great, however great an attorney. It is a constitutional right, and I don't think it is in order and fair for my learned friend to start getting very angry because the accused person's lawyers are insisting that they must see what he's putting to her.
My Lord, we know the limits of disclosure. We know that before you read evidence, you must disclose. We are not reading evidence, we are cross-examining. This is cross-examination. And my Lord, I am not expected to hand over, because handing over that
Mr. Morgan, cross-examination is continual. I mean, disclosure is continuous. You can, as you come by documents or evidence, disclose. The state is there, the defense. You're leading the witness to a particular document, which you say you are going to come to at an appropriate time, and you will disclose. Disclosure at the back is a practice that is accepted, and that's what has been happening. You disclose to them that you wrote statement, and you move on. So when we get there, so we've spent about 10 minutes on this.
My Lord, can we be left to do that at a point when we have to do so, without the defense bogging us down when we are not yet at that point?
So, Mr. Mwaganya, before you ask any question about the euro account, you must disclose.
That is granted, my Lord.
So,
That is granted, and my Lord, that is exactly what we are going to do. But I am only objecting to the practice of the defense suggesting what we should do before we have to do that.
Mr. Mwaganya, I also thought that the next question was going to be about the
No, my Lord,
because you said we are now going to the euro.
yeah, my Lord, that thinking was not actual. It's not what I was going to do. My Lord, we are seeking for an adjournment to allow us properly conduct this adjournment, my Lord.
Are you asking for an adjournment on what basis?
yes.
Prepare documents for their disclosure.
We want to prepare documents, my Lord, as per the guidance of God for the disclosure.
How much time do you need to you have the documents there, don't you? This file is really dragging.
Yeah, my Lord, my Lord is dragging. Actually, we came ready, but you realize that the circumstances today is that we cannot logically follow through this cross-examination without interruption. It is very difficult. It is very difficult, my Lord.
One party cannot proceedings. The court must control its proceedings.
My Lord, I'm sorry, I didn't get the ground that he had given for adjournment.
Yeah.
Disclose.
No, my lord, this court has already held that he discloses to us at the bar here.
Yes.
So let him disclose to us here.
We can even take pictures.
Yes.
Continue.
My lord, like a jet suggested, we need to get organized. So we are asking for time to get organized.
That is what he wants.
You're not punishing it.
No, we are not, my
You
lord.
are punishing the accused.
Absolutely.
That's what he wants to do.
That's what he's been doing.
No, my lord, I thought Jet is acting for the accused person.
So also you punish.
Also counsel. It's not be listed.
So, my lord, if then the defense, if court agrees that Jet is faulting himself, then can prosecution be protected so that we proceed with the minimum? My lord, it is very difficult to conduct this exercise with this kind of interruption.
My lord, we have no objection to him proceeding, although, my lord, if we see the need to object. Unfortunately, like he has instructions. Also, as in case there is something that we think violates the law, we will certainly raise it before the court. But we are happy to proceed.
My lord, at what stage today? Because as soon as I refer to documents, they echo to demand for it. Are they assuming that we don't know what we are supposed to do?
Mr. Morgan, let us proceed. That matter has been resolved. We are not getting the judgment. Let us at least go up to 5.
Yeah, much obliged, man.
He made an order, my lord, that he serves us.
When he asks
No, when he
questions,
gets, when he starts asking the
yeah, he will give us, yes.
What do you want? What do you want? What do you want? What do you Do I put those stickers?
So as I get the document, Madam Molly Katanga, you confirm that Marge operated the Euro account.
Yes.
Okay. And who were the signatories?
I was a sole signatory.
You were a solo signatory. How about the UDX account?
That accounts, I was a sole signatory.
Including the UDX account?
Yes, please.
I'll come to the accounts marked later for Marge. So let's talk about marks. You confirm that you operated an account for Max Logistics. Who are the signatories?
It was the same arrangement. I was sole signatory.
And your husband was not a co-signatory? Ma'am, was your husband a co-signatory or not?
I was saying no.
Do you understand when I make reference to a signatory? Do you understand me? Okay. Signatory means the people with competence to sign documents on a particular account. Do you now understand me?
Or a person who can go to the bank, sign and get money. That is
I was always the only person.
Not always. I'm asking the actual.
The action is,
Huh? What do you mean?
I was the only one signing.
Only one, okay, that's right. And that is your position for the Euro account and for the UGX.
Yes.
She was the only one.
signing.
No, she was the... No.
She was the only one signing.
Yes, I was the only one. That's what I am.
Are you...
Operated an account for Max. I was the sole signatory. I was the only one signing. That's what.
So your husband was not a signatory on any of these accounts?
He did not sign any.
That is another question, ma'am. That's another question. Was your husband a signatory on any of these accounts where you claim to be the sole signatory? Sole signatory means that you were the only one and no other had the signing mandate. And you're a businesswoman, you know that.
When we were auditing these accounts, it was a requirement by the bank being a limited company that more than two people. So we registered the company as 2 people.
Now I'm not at registration.
No, even in the bank, because you have to present those documents. We presented those documents as 2 people. So in the bank, from the time of payment, I was the only one signing, I was the only one running that company.
But when on the documents, it is you and your husband who are signatories. Yes. But in actual sense of day-to-day running, you sign alone.
Yes.
I have never signed anything.
Yes.
So then you are not the sole signatory.
I was the only one signing.
In the bank documents, you gave 2 names and 2 signatures.
Yes.
So that means you are 2 signatories. But in operation, you are the only one signing.
Yes, I was the only one signing.
But your husband was also a signatory.
At the opening of the documents, yes, but it was not operation in that.
Now that you even make it better, that you were in the most active position of the running of this company, these companies, do you know the particulars of the accounts that you were running?
I can't remember. These are 2.5 years without.
I'm going to ask again how you want to remember the particulars of these your companies. The answer is?
I don't know.
My Lord, before I go to the next phase, I pray to them these first, that two, the first set of documents of the companies that the witness had acknowledged. The MEMATs,
Each one.
for March,
Memorandum and articles.
for March we have the MEMATs, we have the resolution, we have company form 18.
Which resolution?
Resolution for March, the one we have traversed. We traversed this and I put them here.
No, Mr. Wong. Let's see.
18. Company form 18. And then for Max, my lord,
Wait.
Finish March.
we have the MEMATs,
Let's finish.
we have the resolution, we have the company form 18. Bread to tender them as exhibits. Mr. Kavid, are you interested in this?
Let's see. My Lord, I'm not sure if the resolutions include the resolution we've been talking about. The one with the accounts.
I never talked about account resolution when I'm dealing with
These are different resolutions.
company resolution is for the banker statements. She says she doesn't. So let me deal with what she knows.
So I think just to save time so that we don't have to object, Mr. Moore, tendering the company the memos.
Yes.
This is now merged.
Yes.
So you're tendering the memos.
Yes. Yes.
Which end at what we all know we have the
Memos as it is.
No. Unfortunately, they are not page numbers. They end with this signatory page, correct? Then you are talking about a resolution dated 10th September 2024. And then we are talking about Company Form 18.
Yes.
Also dated 3rd day of October 2020.
The details, we shall go to the details, but those are the documents.
Yeah. So my Lord, these ones we have no objection for my the first three.
The merged documents, which are the memos, the resolution, and Form 18 are admitted and collectively marked.
22, my Lord, I propose A for the memos, B for the resolution, and C for the Form 18. For ease of reference and submissions, my Lord.
That's the
Most of them.
the memos, the resolution. Yes.